when it comes to sovereignty, parliamentary sovereignty is particularly important in public law because it's often described as the cornerstone of the Constitution. Now, because we describe it as a cornerstone, we're suggesting that it is a stone that unites two walls of a building in a corner and is therefore the principal stone. Right, that's what we mean when we say it's a cornerstone. All right? Now, the argument is that without that stone, the building would fall, and so therefore it is something of prime importance. Now, of course, in my example, the building is, of course, the Constitution, and parliamentary sovereignty is a key part of that Constitution. Pass those down, please. Thank you. You need to go down there. Thank you. Now, having said that, so my building in my example is, of course, the Constitution. Parliamentary sovereignty is a key part of that Constitution. But obviously, sovereignty can have a legal and a political meaning. And in the political sense, the term sovereignty can be seen to indicate where political power may reside within any one constitution. Now, some examples which you'll see on your handout of political writers who've regarded sovereignty as an issue of politics and of supreme authority are people such as Thomas Hobbes, Jean-Jacques Rousseau, Thomas Paine, and John Locke. Now, I don't intend to go through these in any huge amounts of detail, but when it comes to Thomas Hobbes, obviously the suggestion is that life is nasty, brutish and short, and therefore we should expect some ultimate source of authority. Jean-Jacques Rousseau talks quite clearly about the people's sovereignty. Thomas Paine talks about the conditional surrender of rights. And John Locke is specifically interested in limiting governmental power. Now, each of those theorists are explained in more detail in your textbook, and I say I don't intend in the short time I have to explore them in any more detail. Just suffice to say that obviously it does suggest that sovereignty has a political as well as legal view. I'm interested in legal sovereignty, that's why we're here, and for our purposes it has two divisions. It can have a jurisprudential view, or it can obviously have a constitutional law view. Now, I'll briefly talk about jurisprudence views, and then obviously I'll focus on constitutional views. But in terms of jurisprudence, if we look briefly at the work of people such as John Austin, John Austin suggests that laws are nothing more than the commands of a sovereign. Whoever you decide is sovereign, so they will command, and that's what the laws are, an instrument of that command. Herbert Hart, HLA Hart, which is on your handout, has a more particular view, and he discusses the differences between what's called self-embracing sovereignty and continuing sovereignty. Now, self-embracing sovereignty is a form of sovereignty which would permit the exercise of power to delimit Parliament's legislative power in the future. Of course, if you're delimiting power, the suggestion is that you are surrendering it, and because you're surrendering it, then arguably it can only be exercised once. You can only give power away once, and Hart uses God as an example. Okay, and this is the example, obviously, that I've cited on your handout. He says, quote, "On the one hand, a God who at every moment of his existence enjoys the same powers and so is incapable of cutting down those powers, and on the other, a God whose powers include the power to destroy, for the future, his omnicompetence." Now, that view of self-embracing sovereignty is not the traditional view. All right, so you need to be aware of it, but the more traditional view that you need to have much more awareness of is the idea of continuing sovereignty. Okay, and continuing sovereignty as advanced by Dicey. Okay, now we spoke about Dicey this morning and this afternoon in the seminars, and I said he was of particular importance in public law in this country. And for parliamentary sovereignty, he's certainly particularly important because in his book, The Introduction to the Study of the Law of the Constitution, in 1885, he makes it very clear as to what his view of sovereignty is. And his view is essentially the power of lawmaking unrestricted by any legal limit. Now, to avoid any confusion with political sovereignty, some public lawyers prefer to talk about legislative supremacy. All right, it doesn't matter which of these terms you use, whether it's parliamentary sovereignty or legislative supremacy, the key is to be consistent. All right, so just decide on one phrase, whichever you can remember the most easily, and then just stick to it. All right, and then there shouldn't be any further confusion. Now, importantly, when we talk about Dicey, he did not view the doctrine of parliamentary sovereignty as something vague and abstract. He felt it was a generalisation from contemporary English practice because there was clearly a logical need somewhere for a sovereign. He felt that parliamentary sovereignty was a fundamental rule of the common law and it was therefore for judges to uphold. And it's something we'll talk about later when we refer to the Jackson decision about the positioning of this as a common law rule. Now, his definition of parliamentary sovereignty, or as I say, legislative supremacy if you'd prefer, consists of three key parts. These are all on your handout and are that Parliament may legislate on any topic. Secondly, no Parliament can bind its successors or be bound by its predecessors. And thirdly, nobody may challenge the validity of an Act of Parliament. Now, if we examine each of these in turn to see what they mean for Dicey in generalised terms, so what I plan to do now for a few minutes is to go through each of them just to give you some indication of what they mean in practice, so that obviously when it comes to examinations you might be able to use those to support any line of argument that you make. So we start off with Parliament's power to legislate on any topic. Now, this can include the power to legislate extraterritorially. So, for example, this occurred in the Aviation Security Act of 1982. And in this 1982 Act, Section 1 provides that the crime of hijacking is committed when a person who is on board an aircraft in flight unlawfully seizes control of the aircraft and exercises control of it by use of force or by threats. Now, the point about this legislation is that the jurisdiction of the UK courts, with some exceptions, extends to any act of hijacking, anywhere, and by anyone. There also exists the power to legislate retrospectively. So, for example, in the War Damage Act of 1965, we see Parliament effectively overturn the decision of the House of Lords in the case of Burma Oil Company versus the Lord Advocate in 1965. Okay, and you probably have come across that case in your reading, but it's important to demonstrate that because Parliament is sovereign, it can legislate retrospectively. Now, retrospectivity is obviously not necessarily a popular route, and you may remember from your discussions of the case of R&R, when the marital rape case, that obviously there were some concerns about retrospective activity by the judges. Well, this is just an example of saying actually not just the judges can do it, but obviously Parliament can do it as well. And in fact they did. Parliament, being sovereign, can also relinquish power through grants of independence, as with the Nigeria Independence Act of 1960. And it can also legislate to alter the workings of Parliament And you'll note that it did this both in Parliament Act of 1911 and also the Parliament Act of 1949. And you will remember, because some people have mentioned this morning as far as sources of the Constitution go, that the 1911 Act particularly emerged because something of a constitutional struggle between the House of Commons and the House of Lords. The Parliament Act saw the powers of the House of Lords in respect of legislation being curtailed, and obviously it's important here to show that Parliament can change its own workings. Now finally, when it comes to legislating on anything, two oft quoted examples of literally how sovereign and therefore omnicompetent Parliament is. The first of these is from Sir Leslie Stephen in 1882, where he explained that Parliament could legislate to have all blue-eyed babies put to death. Yeah? Parliament is sovereign, it can do what it likes, and therefore the suggestion is it can put all blue-eyed babies to death. A more commonly cited example is from Sir Ivor Jennings in 1959, when he said that Parliament could legislate to ban smoking on the streets of Paris. Now, there's nothing to stop an English Parliament from obviously passing that particular piece of legislation. Now, immediately we have to issue a warning here, because whilst legally Parliament could do these things, politically, clearly it is unlikely to happen. So whilst Sir Leslie Stephen identifies that example of passing legislation which could kill all blue-eyed babies, he continued to say, quote, that whilst Parliament could kill all blue-eyed babies, the legislature must go mad before they could pass such a law, and subjects be idiotic before they could submit to it, unquote. Yeah? Legally, however, it remains a possibility because Parliament is sovereign. Okay? That's the first point. The second point of Dicey's view on parliamentary sovereignty is that Parliament's power may not be limited by a previous Parliament. So when enacting legislation, the draftsman may not have noticed an inconsistency between Acts of Parliament. And in order to ensure the supremacy of each Parliament, the courts have used the doctrine of what's called implied repeal to the extent to which the two are inconsistent with one another. Now, just a quick terminology check here in case you're unclear, but express repeal, where something is expressly repealed, it's where there is a clear statement that an earlier act or provision is no longer effective, whereas implied repeal is where there is a conflict between two acts and the courts apply the later act. Now, of course, implied repeal does involve some interpretation of the two conflicting acts by the courts. And an example of implied repeal in practice comes from the Vauxhall Estates versus Liverpool Corporation case, 1932. And in that case, we see a conflict between a piece of legislation from 1919 and a piece of legislation from 1925. The question for the court was whether the 1919 piece of legislation could protect itself from later repeal or amendment. The divisional court in this case said no. Why did they say no? Well, for our purposes, they simply said Parliament's hands cannot be tied. If you have continuing sovereignty, then you cannot be bound by previous parliaments. Now, this view is confirmed in the Ellen Street Estates case, and it basically dealt with the same provisions in terms of the 1919 and 1925 legislation. And it was Lord Justice Morm in that case who said, and again I've put this quote on your handout, where he said, quote, "The legislature cannot, according to our constitution, bind itself as to the form of subsequent legislation, and it is impossible for Parliament to enact that in a subsequent statute dealing with the same subject matter there can be no implied repeal," unquote. Essentially what this means that any attempts to limit Parliament's ability to legislate would obviously undermine this core principle, this core cornerstone of the Constitution. Right, so Parliament can do anything. Parliament cannot be bound by previous parliaments. The final point in Dicey's model is that no one may challenge the validity of Acts of Parliament. Now, prior to 1688 and the Glorious Revolution, in Dr. Bonham's case, the judge in that case said that the common law had the power to control Acts of Parliament and could sometimes declare them to be void. But post-1688, and certainly post-1689, which of course saw the Bill of Rights, this is no longer the case. So in the case of Edinburgh and Dalkeith Railway versus Wauchope, it was claimed that provisions of a private Act of Parliament should not be applied because it had been passed without Wauchope having been given notice of it as was required by standing orders. Now the House of Lords in this case disagreed, and they commented, albeit obiter, on what is called the Enrolled Bill Rule. Okay, and the Enrolled Bill Rule is particularly important for constitutional lawyers because it's used where it becomes clear that the courts will treat the mere recital of the consent of the three components of Parliament, and you should remember these components are the House of Commons, the House of Lords, and the monarch, in an official copy of the Act, it will be conclusive. What does this mean for us? Well, as Lord Campbell says, all that a court of justice can look to is the parliamentary roll. They see that it has received the royal assent, and no court of justice can inquire into the manner in which it was introduced into Parliament. What was done previously to it being introduced, or what passed in Parliament during the various stages of its progress through both Houses of Parliament. Okay, we have to assume, because of the Enrolled Bill Rule, that as long as it goes through the process, obviously it is an Act of Parliament. We can't look behind it. And this was simply echoed and supported in the 1974 case of Pickin. And Pickin was obviously a much more up-to-date case, but it was alleged in that case that the board had misled Parliament with a false recital in the preamble to a private act, which deprived him, he argued, in an interest in land. Lord Reid, in that case, affirms the obiter of Lord Campbell previously, because he says the function of the court is to construe and to apply the enactments of Parliament. The court has no concern with the manner in which Parliament or its officers carrying out its standing orders performs these functions. All right, and that's essentially an assertion, if you like, of the Enrolled Bill Rule. Okay, so on the one hand, Parliament can do anything. Parliament is also, because it's sovereign, it cannot be bound by previous parliaments, just as of course it can't bind future parliaments. And then finally, no one, not even the courts, can challenge the validity of an Act of Parliament. All right. Three key points of Dicey's concerns about parliamentary sovereignty, and you need to learn them. All right. Absolutely critical you have a working understanding of what Dicey says in terms of sovereignty. Now, that's all very interesting. Yeah, well, depending on your view, yes. But anyway, it's all genuinely very interesting. But the key now for us to look at is obviously the specific provisions and decide whether we think actually Dicey does still have some resonance today. As you would expect, academics have considered this in some detail and have looked at whether there exist any real limitations on the sovereignty that Dicey holds so dearly. And one key question that often emerges when looking at Dicey and the principle of parliamentary sovereignty is what's called the Act of Union argument. And the Act of Union argument here is referring quite specifically to the union with Scotland and the Act of Union in 1706, and the suggestion by Scottish lawyers that this Act of Union contained provisions which amounted to what's called entrenchment. What do we mean by entrenchment? Well, entrenchment is where an act may be more difficult to amend or repeal because of the procedure which needs to be followed may make it more cumbersome. Okay, it's viewed as a sort of series of hurdles, if you like. Okay, and that's what can amount to entrenchment. Scottish lawyers have argued that the terms of the Act of Union did in fact limit the new Parliament's powers. So in the case of McCormick versus the Lord Advocate in 1953, there was a quite specific objection noted by Scottish nationalists to the designation of the new monarch as Queen Elizabeth II. As a matter of fact, the Scots argued that they'd never had a first Queen Elizabeth. All right? Because, of course, Queen Elizabeth I had been Queen of England, but had not been Queen of Scotland. You may also recall that, of course, Queen Elizabeth I was responsible for the death of Mary Queen of Scots. So this was a particular slide, arguably, to a discussion of Scottish history. But for our purposes, the suggestion was by Scottish lawyers that this contravened Article 1 of the Act of Union. And Article 1 simply says that the two kings of England and Scotland shall upon the 1st day of May, which shall be in the year 1707, and forever after, be united into one kingdom by the name of Great Britain, unquote. On this basis, they argued, to describe Elizabeth II as Elizabeth II was inaccurate. Similarly, in the case of Gibson versus the Lord Advocate, there was an argument made that EEC fishing regulations, which had been made part of UK law under Section 2(1) of the EC Act of 1972, and I'll be talking more about that piece of legislation later, they said that this actually contravened Article 18 of the Act of Union. They said that no alteration be made, and they were citing the Article 18 here, they said no alteration be made in laws which concern private rights except for the evident utility of subjects within Scotland, unquote. Now they are challenges, albeit usually obviously an obiter, and they fail on both counts, both because of the relevancy of the private and public law divide. Okay, and you don't need to worry too much about why they fail. But the key point about these decisions is that some Scottish judges in those decisions suggest that part of the Acts of Union may not be subject to repeal. And because it's not subject to repeal, the argument is that there has in some way been a challenge to the principle of parliamentary sovereignty. And if you look at Lord Cooper in the McCormick case, or you look at Lord Keith in the Gibson case, you can see evidence presented by these Scottish judges. Having said that, those remarks are obiter. Okay, so they're only ever persuasive, and the suggestion is that therefore they are not binding, and they've never again been tested in the judicial setting in that way. Okay, so they are simply something which academics have focused on and said, does this mean there's been a challenge to the traditional view of sovereignty? Now, more recently, this argument was considered in Lord Grey's motion in 2002. And in that case, the House of Lords referred to the Committee for Privileges the question whether the House of Lords bill and at the time it was the House of Lords Act of 1999. Now, House of Lords Act of 1999, you may know or not, removed the right of the hereditary peers, except for 92 of them, to sit and vote in the House of Lords. The Committee of Privileges were asked the question whether this particular provision breached the provisions of the Treaty of Union between England and Scotland. And it was held that Article 22 of the Act of Union, which stated that there should be 16 representative peers of Scotland in the House of Lords, did not have the character of fundamental law, and therefore they said that the Act of Union was not special in any way. All right, so ultimately these three cases are examples of a consideration of the Act of Union argument. They are all they all fail in some way, but they are useful as an illustration that they have been considered at some point. All right, so it's useful, obviously, when talking about limitations of sovereignty, that you do at least consider the Acts of Union argument. Now, there also exists, and if you look at both Hilaire Barnett and also Colin Munro's work, they document what's called the manner and form or redefinition arguments. Now, these arguments are led by Professors Houston and Marshall, and they argue that Parliament may restrict the manner in which a future Parliament operates by virtue of the way future legislation is enacted, or indeed the form that legislation should take. All right, that's why it's called manner and form. So these particular professors argue that Parliament can restrict the manner in which a future Parliament operates by virtue of the way future legislation is enacted, i.e. the form that that legislation should take. Now, this argument particularly arises when it comes to the question of whether Parliament can ever entrench an act in order to avoid later repeal. Now, again, we have a terminology check for you if you're not quite sure what we mean by entrenchment. But entrenchment means that a provision of an Act of Parliament cannot be repealed unless there is a special procedure for its repeal. Now, of course, if you go back to Dicey, he argued, of course, that this could never happen. Yeah, entrenchment wasn't possible. And the reason entrenchment isn't possible is because, of course, Parliament always remains sovereign. But to see if manner and form can actually amount to entrenchment in practice, we have to look at a number of cases. Now, I make no apologies for the next case because the Attorney General for New South Wales versus Trethowan is quite a complicated case. Okay, the facts are quite complex, but as I say, keep concentrating. I realise it's 25 to 6 on a Sunday afternoon after a very long day, all right? But even so, keep concentrating. Okay. The Colonial Laws Validity Act of 1865 was passed by the UK Parliament. Act of Parliament passed by the UK Parliament. And it provided that laws made by the legislature, i.e. Parliament of New South Wales, should be in the manner and form which is prescribed by, amongst other bodies, the New South Wales legislature. In 1929, the New South Wales Parliament enacted a provision, which was Section 7A of the Constitution Act of 1902, but don't worry too much about that. But they enacted a provision which provided that various bills on constitutional matters had to be approved by referendum before they were presented for royal assent. The entrenched or constitutional matters included the existence of the Legislative Council, which was essentially the upper house of this particular legislature, and Section 7A itself. That's 1929. 1930, bills of the New South Wales legislature were presented for royal assent, and this abolished the Legislative Council, and it repealed Section 7A without a referendum being held. So whilst the earlier legislation had said a referendum had to be held, the latest legislation, basically presented for royal assent, argues that this can, well, just simply does it without a referendum being held. And the question for the courts was whether the courts could prevent the bills being presented for royal assent on the basis that it was unlawful to do so without a referendum being held. So the question is, could injunctions to prevent actions by the new legislature be upheld? Right, that's what the court was concerned by. And it's the Judicial Committee of the Privy Council, who at this time were sitting as the Court of Appeal for the Commonwealth, and they upheld the injunctions, and this prevented the bills from going for royal assent without referendum. What does that mean? Well, the decision, therefore, provides some persuasive authority that Parliament's sovereignty can be modified to amount to an attempt of entrenchment. Okay, so some example there, well, one example, there are others, but one example there of where it could potentially amount to entrenchment. However, you need to be very careful about citing this particular case, because the question for us is whether the UK Constitution has an equivalent to the Colonial Laws Validity Act, i.e., does it have a higher law which binds our Parliament in the manner and form of its enactment? The answer is no, there is no higher law, and therefore the argument's been made by people such as Colin Munro is that it can be distinguished, the Trethowan case, from any of our cases, because the suggestion is, unlike in New South Wales where there was a higher law, there was no higher law in this particular example. There are a couple of other cases I've put on your handout, Harris for Minister of the Interior and Bribery Commissioner Ranasinghe. Both of these obviously are of interest, but I don't have time today to talk about them. But the question for us as public lawyers is whether Trethowan and those other cases can apply to the UK Constitution. And this is where it really does become a question of varying decisions as to whether you support the line of people like Houston and Marshall, who presented this manner and form argument in the first place, or whether you support other people. So, for example, Houston and Marshall say, yes, Parliament can bind its successors. Wade and Munro, however, that it cannot be changed by Parliament, especially when it's the Enrolled Bill rule, because it's a special rule, in whatever manner and form. Okay, so their argument is that even if Parliament wanted to, arguably they take the view that it could not. Okay, so be very careful about necessarily applying the New South Wales Trethowan case to UK's version of parliamentary sovereignty. When it comes to contemporary operation of the doctrine, and I'll be talking about some of these in later lectures, but when it comes to the UK Parliament and what was obviously the European Community, you need to look at the specific provisions of the European Communities Act. And the European Communities Act of 1972 essentially implemented the Treaty of Accession by which the UK committed itself to the European Communities Treaty. Now, the principal provisions for us are sections 2.1, section 2.2 and section 2.4. All right, and if you look at the EC Act in more detail, you'll see which relevant provisions are there. 2.1 and 2.2 are quite useful in terms of delegated legislation and directly effective EC law, but it's section 2.4 for us, which is particularly important. And section 2.4 says that any enactment passed or to be passed shall be construed and have effect subject to the foregoing provisions of this section. What does that mean? Well, the suggestion is that by passing section 2.4 of the 72 Act, Parliament attempted to bind its successors as to the effect of future legislation. Clearly, this is contrary to the traditional doctrine of parliamentary sovereignty. And it was in the Factortame case that the courts had to consider this issue. The effect of this and I am conscious of time, but the effect of this was essentially, when the courts considered it, and we'll talk about it in more detail when we do a law of the EU, but the effect of it was to say that EC law essentially had qualified the doctrine of parliamentary sovereignty, in as much as all matters of EU or EC law, the doctrine of implied repeal would not apply. Okay, so what that means is that we can still expressly repeal, because that's still an option, but whereas implied repeal generally applies to all legislation, when it comes to provisions which might be contrary to the European Community Act and subsequent EU legislation, then this is not possible. Again, legally, obviously, it's possible for Parliament to expressly repeal their membership of the Union, and certainly at the present time there are people who would call for that, but politically at the same time it is unlikely. Right, so express repeal is a possibility. Implied repeal, however, for EU matters is not. Next issue is devolution. The Devolution Acts, which obviously devolve power to Scotland and to Wales, the concern is here about the process as to whether power has been sort of surrendered, and therefore, having been surrendered, can it be taken back? Well, the argument is that there are provisions within that legislation which will actually ensure the continuing sovereignty of the UK Parliament. Okay, and again, when you look at this legislation in more detail, you may be able to provide and find reference to those continuing sovereignty provisions. Human Rights Act. There are three methods of protecting rights. The first of these is entrenchment, which we've already talked about, where you provide hurdles for people to make amendments. The second of these is a strong presumption of compliance. And for strong presumption of compliance, the argument is that you, as in Section 2.4 of the European Communities Act, you say that if there is a conflict, then European law must prevail. Or then you have a weak presumption of compliance, and this is, for example, what appears in the Human Rights Act. It's a weak presumption of compliance because Section 3 of that Act says that so far as it is possible to do so. All right, so rather than saying if there's a conflict it must prevail, as in EU, so for Section 3 of the Human Rights Act it says so far as it is possible. This is a weak presumption of compliance. We then have the challenge as per Parliament, the Parliament Act of 1949 and the Jackson case, which again I've been referring to this morning. And the Jackson case was a case from the House of Lords which concerned the passage of the Hunting Act, which obviously outlawed hunting with dogs. It was a manifesto commitment of the Labour Party, but of course there were particularly loud objections to this piece of legislation, but by virtue of the Salisbury Convention the expectation was that the House of Lords would obviously roll over and allow this to be passed. It was rejected by the Lords, and so the government decides to push through using the procedure in both the Parliament Act of 1911 as amended by 1949 to circumvent the approval. Jackson argued in this particular case that hunting had been passed under the provisions of the 49 Act, and this itself was an unlawful extension of the 1911 Act. As a result, the House of Lords had to think about whether the 1949 Act was in fact fully effective. Unsurprisingly, they did. They confirmed the sovereignty of Parliament, but, and this is the key, they also comment that parliamentary sovereignty, this refers to back what I said at the beginning, parliamentary sovereignty, they said, is a rule of law, and therefore it's a gift of the judges. And they said, just as they can give it away, so they can obviously take it away as well. Yeah, they can give effect to parliamentary sovereignty, so they can also choose not to give effect to parliamentary sovereignty. Now, clearly whether that amounts to much in practice is a different question, but it's worth reading the case as a whole. If you've got to read any case from parliamentary sovereignty, read that one, because it's a reaffirmation and reconsideration of the particular issues when it comes to parliamentary sovereignty. There's also finally been this other argument which has emerged as a contemporary issue, which is the emergence of the idea that certain statutes have constitutional status. Okay, and you'll see reference to this in your textbook. But the argument is that although, for example, some acts of Parliament may have a weak presumption of compliance, i.e. the Human Rights Act, of course the only suggestion, and again this comes up at a later point, is that they are only in reality likely to be capable of express repeal. Having said that, this again is only an argument which is raised in the context of particular decisions, and it has never been applied. So, for example, in the Thoburn case, when they were looking at EU law, Lord Justice Laws said that there were two types of statute. He said the first was an ordinary Act of Parliament which could be impliedly repealed, and the second was a constitutional statute, which, because it deals with the legal relationship between citizen and state, and therefore it either enlarges or reduces the scope of fundamental rights, and therefore it wouldn't be subject to implied repeal, it could only be subject to express repeal. Okay? It's just an argument presented in a particular case. Okay? Academic lawyers have sort of seized on it as an example, if you like, of one of the restrictions to the traditional view of sovereignty, but at the same time other people have simply said it's one case. Now, the recent development I wanted to refer to here is the European Union Act of 2011, and this was really a sort of beast of political interest, really, because the aim of this act was to reconnect people to the EU, because people essentially felt, certainly the general public here seemed to feel, that decisions had been taken in their name without their direct control. Now, I'll talk more about the specific provisions of these when we do EU law next time, but for our purposes in terms of sovereignty, the Act says that if there is a change to the EU treaties that moves a power or an area of policy from the UK to the EU, then the government will have to get the British people's consent in a national referendum before it can be agreed. All right? So this is an important, supposedly, development. There's also a provision in the Act which underlines the legal principle that what a sovereign parliament can do, a sovereign parliament can also undo. Okay, and again, this is an assertion of sovereignty. All right? Now, in concluding then, the slavish observation of the doctrine by the courts has been criticised for its reluctance to adapt to the needs, certainly that some would argue, to entrench. And the big example here is the Human Rights Act. Yeah, people say people's rights would be much better protected if you had entrenchment. And Allen argues, quote, that when constitutional debate is opened up to ordinary legal reasoning, based on fundamental principles, we shall discover that the notion of unlimited parliamentary sovereignty no longer makes constitutional sense. Yeah, the inability to bind successive parliaments, according to Allen, is erroneous and doesn't make constitutional sense. But Ewing, and I think this is probably more critical, says that actually parliamentary sovereignty is the most democratic of all of the constitutional principles that you look at. Why? Because he says, quote, it is the legal and constitutional device which best gives effect to the principle of popular sovereignty. Because he says the people in a self-governing community are empowered without restraint to make the rules by which they are to be governed through the medium of elected, representative and accountable officials, unquote. The idea to Ewing of continuing sovereignty is that, yes, I can't bind Parliament for tomorrow, but equally I can't be bound by what people said yesterday. And it's that idea of continuing sovereignty, which he argues is the most democratic of all constitutional principles, because I vote in a government or a legislature, and obviously part of them will make up the government, and they will be relevant for today rather than being hampered by what happened yesterday and not being able to bind what happens in the future. And that's why Ewing places great stock in the basic principle of parliamentary sovereignty. So whatever you decide, and there'll be some of you who think this is loathsome, it was terrible, the very idea of it. Other people who think actually it's a really good idea to be continually sovereign. Whatever you decide, as far as your assessment goes when it comes to the UK, I think you should really argue that it does remain the cornerstone of the UK's constitution, but it has been qualified at points. And the most important qualification is the role of the European Communities Act. Okay, and when you look at it in more detail, you'll see that that is the point at which you need to be aware of.